Hey evidence class, Dan McKenzie here. I'm coming to you from Ottawa. I'm really sorry I can't be there today to discuss these issues with you in person, but we'll do the best we can in the circumstances. And I've got a lot to cover relatively quickly if I can, so we'll get right down to it. Hopefully the trial that we just put on, you were able to see both an effective examination in chief as well as an effective cross-examination where Mr. Kofsky's credibility and the reliability of his testimony were effectively called into question. That's if they stuck to the script. I really don't know. And that's the main part of my presentation, is I really want to reinforce that both with examination in chief and with cross-examination, for very different reasons, they are really art forms. And we don't really do a lot of that. I mean, I suppose in our oral arguments in our first year moots, we get to sort of work on the art form of law, but really we study so many rules and things like that. So this is kind of why we wanted to get into this topic, is it really is an art form. And the ability to undermine the credibility and reliability of evidence in cross-examination, and also with examination in chief, to find a way to really present borderline unassailable evidence, if possible, has never been more important. And we've sort of seen that. We've been talking about, you know, the Jeremy Bentham everything admitted and then undermine the reliability if it's not reliable trend. And we've sort of seen a little bit of that in evidence law in the past 20, 30 years, is that there's a greater trend towards admissibility and then having the weight of that evidence to be assessed based on the reliability at the cross-examination stage and both examination in chief as well. And if I can quote Kellowan, which is the case we would have read last week discussing the principled approach, that the Supreme Court of Canada said, "Our adversarial system is based upon the assumption that sources of untrustworthiness and inaccuracy can best be brought to light under the test of cross-examination." And that's not really a new concept. We've seen it for hundreds of years, that cross-examination is essential. And I got to read a few chapters from a book written in 1902 by a man named Francois Wellman, an American, called The Art of Cross-Examination. And essentially he states that cross-examination, more than the oath, more than anything else, is the best manner we have to undermine reliability. And once again, we need to reinforce that, unlike maybe the trial you saw today where Mr. Kofsky was just outright lying about the testimony he saw, the vast majority of the time, based on the material I've read, it seems to be that it's not so much that people are outright lying, is that there are often genuine misinterpretations and misperceptions, I'm not sure if that's a word, about the evidence and what happened. We saw in the My Cousin Vinny cross-examination, I'm probably fairly confident that that man genuinely believed that he saw those people steal from that convenience store. Or did they murder him? I'm not sure. But essentially, it is the idea that people have genuine misinterpretations of what occurred, and you can undermine that reliability. How far were you? Were you wearing your glasses? Was it nighttime, etc.? And that's the core reason we have cross-examination, and it's our best form of truth-seeking within the litigation process. And it's one of those things, as I was alluding to, it is an art form because it really requires you to think on your feet. All the preparation in the world, which is important, preparation will be everything, but you never really know what they're going to say, and that's the same fear one has with a moot or in a trial process of any kind, is you don't know what kind of questions you're going to get. It's the same in examination in chief and cross-examination. You don't know exactly what the witness is going to say, so you have to be able to adjust your line of questioning accordingly, and it's one of the hardest things to do. It's going to be one of the hardest parts of our jobs for those of us that go on to litigate. So I'm going to talk about both examination in chief and cross-examination, and I've had a chance to read through quite a few different articles and sort of opinion pieces on what makes effective cross-examination, what makes effective examination in chief, some basic tips and some limitations for both. And I'll try to go through those as best we can and give some tips. This is by no means a massive overhaul, and you won't walk out of this knowing how to do any of this maybe, but it's always good information. And keep aware that these are subjective opinions. There's no one way to do any of this, but these seem to be some of the main points I've taken from these various sources. So examination in chief. Unlike cross-examination, you really want the counsel not to be at the forefront of what's going on. They're not leading the charge, or maybe they are, but you don't want it to be appearing that way. So you kind of want to be the puppet master, but you don't want the strings to be visible. It really has to be seen that the witness is just giving their story, and you're just wanting to seek elaborations in various parts and other factors. In a case called the Crown and Caron, it's a 1994 Ontario Court of Appeal case, sort of explains this concept that it's not the role of counsel to present a story and then ask yes or no, is this what happened? That is a good example of leading question, as I'm sure Drew elaborated on earlier. It really needs to be questions that they can explain and elaborate, and it can't look like counsel is sort of making it for them. And the main key is that you want to make cross-examination essentially fruitless. You want to make the evidence presented unassailable. And it's a hard thing to do, but one of the ways to do that is to, in examination in chief, bring to light some of the frailties with your witness and some of the reliability or credibility, and address it in that light with you as counsel sort of leading that route. So that's the main point, it seems to be, that I've heard so far with cross-examination, is it really isn't counsel that's supposed to be seen as the one leading the charge, even if that is the case. So, moving on to cross-examination. Cross-examination is really the opportunity for counsel to be at the forefront and leading the charge, and you want to be the people in the movies. You want to be Matthew McConaughey in A Time to Kill, ripping his shirt off or whatever he's doing. Maybe that's Magic Mike, I can't keep it all together. But that's when counsel really gets to step up and do their thing. And the best way to do it, particularly in circumstances where people are maybe attempting to hide something, you can't really approach the problems dead on. You would have seen Riley give a good example in his cross-examination of Mr. Kofsky. He didn't go a direct route with it. He didn't just outright ask the first questions. You sort of lead them down the garden path, as the judges tend to try to do, and then get around to it in different ways. And it's such a difficult task, and one of the ways we often think about the Matlock version, where they're going around and just they're asking the actual killer the questions, and eventually they confess. But it's not really the point for that to be the case. And two particular examples of situations where it's particularly difficult would be with adults with disabilities, perhaps, as well as children. If you are representing someone who's accused of victimizing either of those types of people, you really don't want to come across as the bad person trying to undermine their credibility and reliability, and it's such a fine line to cross, and it's such a difficult thing. But it essentially, again, is preparation. It's even more important to be prepared in examination in chief, because it's not your witness. You may have a better idea of what your witness is going to do, but with cross-examination, preparation is everything, and being able to think on your feet and sort of leading the charge, taking the witness down the road that you want to take them. So those are the main points I want to reinforce, is that it really is an art form, and it's never been more important for cross-examination and both examination chief, as we have this greater trend towards admissibility. These are some of our best methods of testing evidence and presenting it in the ultimate aim of seeking to ascertain the truth. So those are my main points, and hopefully that was somewhat informative, and I'm happy to pass on some of the citations to any of those articles I was reading if anybody is interested. Thanks very much.